get challenged, right? And to what extent do you defend yourself, or what are those triggers, or where does it become worth it? And the example was, I was at a company many years ago, and this is where I'll date myself. Some company received a fax from our company that kind of truncated some of the last letters of our company name, but when they did that, it looked somewhat similar to the company that received the fax, and it's a well-known company, very entrenched in sort of all this stuff. And the company challenged the company that I was at, and the end of the day, the in-house attorney decided to acquiesce, and we changed course, as opposed to fighting it out in court and spending all that money. So how does that fit with you? Where do you when it comes to these sort of not gray areas, I guess, for lack of a better way to describe this, what should a company do? When do you hold them and when do you fold them, I guess is the best way that I could describe this.
Right. Well, that's an excellent question. And unfortunately, trademark law, when it comes to infringement, it's a subjective thing. So, in my experience, trademarks usually, and infringement of trademarks, they usually generate an emotional reaction. The plaintiff usually says, "Hey, that's mine. I've been building that brand for decades, and yours is too close to mine, and it's going to, cause consumer confusion." Unfortunately, the defendant's intent is not necessarily the most important thing. So, I mean, obviously, if the defendant's intent is to rip off the trademark owner, that goes to willful infringement. But if the defendant's intent is just to use a trademark, and they kind of innocently adopted something, and they may have, truncated something, and that truncation causes problems. Unfortunately, it becomes this subjective battle between what the plaintiff perceives and what the defendant is trying to accomplish. Now, I will say that sometimes I'm actually dealing with a case like this right now. The truncation is done where it takes a name that's, let's say, a couple of words or a couple of names, and it truncates it down to a couple of initials. Oftentimes what I've seen is the plaintiff owns a registration for the initials, and they want the defendant to stop using the initials. And it turns out that the trademark space is very congested with these types of initials. So if you do the analysis, and it takes a lawyer to really look at this, unfortunately, but if you do the analysis and you find that there are a lot of these initials out there and they're all peacefully coexisting, then you can push back to the plaintiff and say, "Hey, look, ours is just another one of these initials, existing in a big space. So, we should be able to peacefully coexist." Now, that may work or that may not work. If it doesn't work, this goes to your question of when to hold them and when to fold them. Keep in the back of your mind that when trademark disputes arise, the plaintiff is complaining about the name you chose. They are not complaining about your business, generally speaking. So the idea is, if the trademark infringement plaintiff really digs in their heels and comes after you, then you always have the option to capitulate and just say, "Look, okay, we're not going to use these initials, or we're not going to use this trademark anymore." That doesn't prevent you from doing your business. It just means you maybe have to rebrand. Best way to prevent that from happening is, even before you adopt the trademark, do a search. Make sure there's nobody in this space, see what the lay of the land is. And if there's a possibility the mark may be truncated, do a search for the truncation as well. So I hope that addresses your question.